Hi, my name is Michael Burstein. I'm an estate planning and probate attorney with offices in Culver City and Manhattan Beach. This is the third in a series of videos wherein I attempt to explain the rudimentary basics of estate planning and probate. In the first video, I simply introduced some concepts, and in the second video, I discussed probate itself. With this video, number 3, I wanted to introduce the living trust. Most of you have heard about living trusts, whether you know much about them or not. Some of you have heard the term family trust, sometimes revocable trust or revocable living trust. Essentially, a living trust is an estate planning document that virtually everyone today gets as their foundational estate planning. It has replaced the will that our parents or grandparents and those preceding them all had. A living trust is a document wherein you indicate who you would ultimately like to be in charge of distributing your estate, as well as who you would like to receive your estate. And sometimes those are the same people, and sometimes they are not. But I frequently get asked on the telephone or in client meetings, can the person in charge of distributing my estate in a living trust, we call that person a successor trustee, be one of my beneficiaries? And the answer is yes. Sometimes it is appropriate for that person to be a beneficiary, and sometimes it shouldn't be that person, or maybe it should be a third party. The trust department of a bank, a trust company, a CPA, or depending on the situation, a family friend. That is something between you and your attorney. A living trust is very similar to a will in that your estate is distributed, you select someone to distribute it, but the difference is that your estate does not have to go through the probate system. And the probate system is one thing that most people, given a choice, want to avoid. Living trusts have been around in this country almost since, if not since, the beginning of this country, but they only became popular in the 1980s, and California led the way with living trusts in the popularization of them. Today, the vast majority of clients start off, regardless of their economic status, with a living trust, and then, depending on their situation, we create other documents on their behalf. In our next video, we'll describe what makes a living trust the effective vehicle it is and why it is that it avoids probate.